Hello folks, and welcome back. In this presentation, I'm going to be covering checks, payments, and payment systems. This will be the penultimate presentation. Okay, the last one being lending and secured lending and the banker's lien. Okay, so within these last few chapters, there is going to be a little bit more information surrounding accommodation bills and accommodation parties that tie into what we just covered in the last chapter, bills of exchange, okay, and how we can use some of this knowledge for our benefit, but a lot of it is going to be quite trivial, but there's certainly going to be a few pearls of wisdom here just to gain, a better understanding in regards to banking, okay, and how the bankers are seeing things and how the law is surrounding kind of operations that these bankers get up to. Okay, so with that being said, let's dive straight into it. So we have duties of the banker. The banker is under a contractual duty of secrecy, at least in respect of the transactions which go through the account and any of the securities taken by the banker. A banker has a duty to certain third parties who are beneficiaries of trust accounts. So checks, the structure of the Australian payment system has changed rapidly in recent years. In the first edition of this text, it was reported that the check was responsible for almost 65% of all debits to bank accounts in terms of numbers of transactions. The check was the main method used for non-cash payments. Various forms of electronic and card access methods have largely replaced the check as the customer method of accessing bank accounts. The decline in the use of the check is shown in figures published by the Australian Payment Network, okay, where in 1994, there are about 110 million checks written per month. As compared in 2017, check use has declined by 60%, okay, between the years of 2012 and 2017. It's probably even more here when this is recorded in 2024. So we have Section 78, the Bills of Exchange Act, defines a check as a bill of exchange drawn on a banker payable on demand. Definition, recall that a bill of exchange must be payable to a specified person or to bearer. To be a check, the bill must be drawn on a banker. Okay, Section 10 of the Cheques Act changes that slightly, where a check is an unconditional order in writing that is addressed by a person to another person, being a financial institution, and is signed by the person giving it, and requires the financial institution to pay on demand a sum certain of money. Okay, note, in this act, financial institution has a restricted meaning. See the definition in subsection 3.1. So an instrument that does not comply with subsection 1 or that orders any act to be done in addition to the payment of money is not a check. So there are two notable differences. We have a check must be drawn on a financial institution, not necessarily a bank, and two, no payee needs to be specified. The first extends the instructions which may issue checks, that is, those institutions on which checks may be drawn. Okay, prior to 1998, only banks could issue checks, a privilege which gave them a substantial competitive advantage over other financial institutions. The developments in electronic payments have rendered this much less important than it was in 1986. Okay, the ability to offer third-party payments is essential to attracting depositors. Established banks fought long and hard to prevent building societies and credit unions from being able to enter the check system. So neobanks do not offer check facilities, relying entirely on electronic payment products. And we have the second difference overcomes decisions such as Orbit Mining and Trading Co. Limited versus Westminster Bank back in 1963, which held that an instrument made payable to cash or order was not a check. Under the Cheques Act 1986, the instrument would now be a check payable to bearer. Okay, as a practical matter, there is one further important difference from bills of exchange. Checks are not accepted by the drawee. This means that the drawee institution is not liable on the check. The drawee institution will generally be contractually liable to the drawer to pay the check as like an agent, okay, provided it is in order and funds are available, okay, on account. It has no contractual or statutory duty to the holder to pay as it would if it had accepted a bill of exchange. So we have a order and bearer checks. The Cheques Act 1986 changed the definition of bearer and order instruments. Section 21 determines when a check is payable to order, and then Section 22 declares that any other check is a bearer check. Okay, a check is payable to order, Section 21, if the check is expressed, whether originally or by endorsement, to require the drawee institution to pay the sum ordered to be paid by the check to or to the order of, okay, either A, a person specified on the check as payee or endorsee, or B, two or more persons specified in the check jointly or in the alternative as payee or endorsee. When the check is dated, there is a rebuttable presumption that the check was drawn on that day. On the other hand, a check need not be dated at all to be a valid check. The drawer and others are not liable on the cheque if it has not been presented for payment. We have types of cheques. Where the customer is entitled to access the account by cheque, the drawer institution has a contractual obligation to pay the cheque, provided that 1, the cheque is a proper mandate, that is, it is drawn in the proper form and signed by a person who is authorised to draw on the account. 2, there are funds available to meet the cheque. 3, there are no legal impediments to the banks honouring the cheque. And 4, the cheque is properly presented for payment. So bank cheques, it is not usually wise to accept a personal cheque from a stranger, since the cheque is commercially no more valuable than the credit of the parties who have signed it. There is, however, a need for an instrument for making large value payment, which is safer than cash. In Australia, for example, that instrument has been, and in many cases remains, the bank cheque or bank draft, which would be the same the world over. Form and legal characterisation. So a bank cheque will be issued by a financial institution at the request of its customer. The institution will normally debit its customer's account for the amount of the bank cheque plus any fees involved. The bank cheque will have the payee named by the customer and will be delivered to the customer. The financial institution is both the drawer and the drawee of a bank cheque. The institution orders itself to pay a sum certain to a particular person or bearer. So the commercial community generally treats bank cheques as having the same commercial status as cash. And the increasing use of electronic payments, particularly in conveyancing transactions, should see the gradual demise of the bank cheque. Crossings, a crossing on a cheque has the effect of restricting the effects of transfer and the method of payment. Crossings were originally placed on cheques by bankers in the process of clearing. In the original clearing houses, each banker had a box with his or her name marked upon it. The clerks from the collecting bank would leave cheques drawn on the banker in the box so marked. But in order to indicate the bank to which payment was to be made, the clerk would cross the cheque, that is, write the name of the collecting bank, between 2 transverse lines on the cheque. As the practice became known to the general commercial community, it was recognised as a significant safeguard against fraud. If the name of the payee's bank was known to the drawer of the cheque could be crossed at the time of drawing. Since the collecting bank was likely to be small and to know most of its customers, it would be nearly impossible for anyone other than the named payee to have the cheque collected by the bank named in the crossing. Because of the practice of bankers, it would be impossible for the cheque to be collected by any other bank. So when the name of the collecting bank was not known, it became customary to merely mark the cheque with 2 parallel lines, omitting the name of a particular bank. Sometimes the words bank or and company were written between the lines. In all cases, the general crossing, as this form became known, was interpreted as an instruction that the cheque was only to be paid to another banker. Okay, that is, the cheque was to be collected by a bank and not to be paid over the counter. So crossings were given statutory status by a series of acts, commencing with the Cross Cheques Act 1856 in the UK. This tradition was continued in the Bills of Exchange Act and is now found in Part 3 of the Cheques Act. So the effects of a crossing acts as a direction by the drawer to the drawee institution not to pay the cheque otherwise than to a financial institution. Okay, the words "not negotiable" written on a bill of exchange, which was not a cheque, have been held to make the instrument non-transferable. However, nothing written on a cheque can have the effect of making it non-transferable. So we've got Section 56 of the Cheques Act, authorises the drawer or any person in possession of the cheque to add a crossing. Then we've got negotiation. Section 39 provides that every cheque is transferable by negotiation until it is discharged. So like bills of exchange, the law relating to cheques protects transactions rather than ownership, and the method of negotiation is similar to that of bills of exchange. Okay, a cheque payable to order is negotiated when endorsed by the holder and delivered so as to complete the contract arising out of the endorsement. We have endorsement under Section 41. 1 sets out some requirements of a valid endorsement expressed negatively. 1, an endorsement of a cheque is not effective to transfer the cheque by negotiation unless A, the endorsement is written or placed on the cheque and signed by the endorser, and B, the endorsement is an endorsement of the entire cheque. So we've got endorsement may be written on an allonge, that is a slip of paper attached to the cheque to give room for further endorsements. Problems arise when a person signs as agent. Again, the problems are similar to those encountered in bills of exchange we covered in the last video. As with bills of exchange, it is as though a cheque is born when it is drawn and delivered, and it dies when it is discharged. Okay, payment in due course means that the cheque is paid to the order in good faith and without notice of any defect in the holder's title, or that the holder has no title to the cheque. So a person may sign not in their own name, but in a business or trade name. Okay, Section 31 provides that the person is liable on the check as if the person had signed in the person's own name. Partnerships also pose a special case. The signature of the name of the firm is deemed to be the signature by the person signing of all persons liable as partners of the firm. Then we have the drawer of a check makes certain promises and takes on certain responsibilities. Section 71 sets out the liability of the drawer, subject to certain exceptions. The drawer promises that 1, the check will be paid on due presentment for payment, and 2, if the check is dishonored or if presentment is not necessary and the check is unpaid after its date has arrived, the drawer will compensate the holder or any endorser who is forced to pay the check. Endorsing a check places certain responsibilities on the endorser. By the act of endorsing, the endorser promises that the check will be paid on due presentment. And we have this common law duty is backed up with the Cheques Act, okay, where that section requires the drawing institution to pay or dishonor the check as soon as reasonably practicable. Okay, the duty to pay checks is not an absolute duty. It only arises when certain preconditions are met. In general, the duty to pay arises when 1, the check is a proper mandate, that is, it is drawn in a proper form, is unambiguous and signed by a person who is authorized to draw on the account. Okay, you can see that particular case. 1, there are funds available to meet the check in that particular case, and there are no legal impediments to the bank's honoring the check. Examples would be garnishee orders against the customer or a Mariva order, okay, that the check has been countermanded. And 3, the check is properly presented for payment. So the bank may refuse payment if any one of the conditions is not fulfilled. Although the institution may refuse to pay if there are insufficient funds, the check is considered to be a request for an overdraft. So if a check is not payable to order, then it is payable to bearer. And the duty of the bank is simply to pay whoever might be in possession of the check. Okay, an order check must require the drawer institution to pay, or to the order of a person specified in the check as payee or endorsee, or to 2 or more people so specified. A person can only be specified if the person is named or indicated with reasonable certainty and is not a fictitious or non-existing person. In this rather roundabout way, a check drawn in favor of a fictitious or non-existent person is payable to bearer. You can see that codified in that case for a discussion of the meaning of fictitious person, which you know that all these entities are, which is quite interesting. And then we have the collecting institution. Okay, when presenting the check for payment, the collecting institution acts as agent for the holder of the check. As agent, the common law requires the institution to act in the interest of the principal, in this case, the holder of the check. Okay, the collecting institution therefore has an obligation to present the check for payment and collect the proceeds for the account of its customer. Presentment by individuals. Due presentment by a person other than a financial institution means the person must exhibit the check, okay, in person at the proper place in relation to the check at a reasonable hour on a day when the jewelry institution is open for business at the place where the check is exhibited. Exhibit apparently means to physically display the check itself. Okay, the proper place depends on the face of the check itself. If the check specifies a place of business of the jewelry institution, then that is the proper place. Otherwise, the proper place is the place of business of the branch of the jewelry institution where the account on which the check is drawn is maintained. Okay, we've got presentment by particulars, due presentment for payment by transmitting the information on the check rather than the check itself. The designated exhibition place is in effect the clearinghouse for exchanging checks. We have conditional payment. Payment by check is conditional payment. The condition to which the payment is subject is a condition subsequent, namely that the check will be met upon proper presentment for payment. Okay, if the check is presented and paid, then the contractual time of payment as between the creditor payee and the debtor drawer is generally taken to be the time at which the check was delivered. You see that codified in that case. So obligations on the check are autonomous and separate from the underlying contract, and the courts have shown themselves reluctant to do anything which would interfere with that autonomy. Not an assignment of funds. Okay, the check is not an assignment of funds held by the bank on behalf of the drawer. And the only obligation owed by the bank to the payee is to deal with the check promptly. Okay, as agent, the check is merely a mandate, not a transfer of rights. Okay, so my comment. Can we draw a check to ourselves from the private to the public? This is, these are questions I'm posing to myself and scheming. All right, on my whiteboard and within my own mind, my vision board, as it were. For instance, can the straw man draw a check from the private offset account to order payment to one of your personal accounts? Check is otherwise just an order for a transfer of funds, okay, from one account to another. Maybe we can make a demand to transfer funds from the private account and into the public. You can certainly try and negotiate the security that is your birth certificate and you know the proper laws surrounding these negotiable instruments and the parties involved, right? With we, us, our straw man setup, especially the straw man birth certificate, registration number, account, and the name of the father and the son or the daughter, the living given name. Okay, so we can start really thinking about this. Even promissory notes can be drawn and used, all right, but do your homework and think how you can utilize this going forward. Even maybe being able to negotiate with the broker or clearinghouse directly to monetize the security you draw up. Okay, you'll need to do more study, but all these doors will open up to you as you understand more of the subject. Okay, and this is where you've got to be very careful. This is why I'm not going to give any advice, because this is obviously where PJP obviously tripped up a little bit when trying to issue those checks. And the things that he was maybe doing with his birth certificates that we don't know, I don't have knowledge, okay, full knowledge of, what actually he was doing and getting up to, okay. But at this latter stage of the journey, that's why, it's so important to have the indemnity bonds in and, have yourself indemnified by the Crown through the name of the father, or at least the straw man too, and signing on behalf of them as surety, okay, on these bond instruments, which are backed by the birth certificate security, which is obviously linked to the prepaid unlimited exemption account. And just, take time in thinking, drawing up a plan as to how you feel like this can work, given the knowledge that you've obtained. Okay, and once you understand how the system works with these bills of exchange and negotiable instruments and what we have at our disposal, okay, you'll certainly start coming up with a lot of ideas. All right, and the sky's really the limit with this. It's just a matter of, again, coming up with a plan, making sure that it is watertight and fits in with, covering yourself with the indemnity bonds, etc. Formalizing agreements, which can also indemnify yourself and lock in a contract through, silence is acquiescence in that sense. And just making sure you're doing things that is lawful. All right. And just spend some time maybe drafting up a little plan and trying these things out. I'm trying a lot of things out at the moment. And if I do have success, I will share a little bits as to how I did it, but I think it's important at this point to basically get up to speed. And with this kind of knowledge, everyone should be kind of following the same systems and mechanisms and transmissions in order to try and find the remedy, right? With what we speak of, with what's been covered in the Advanced Treasury Pack, and how to utilize these bonds and agreements that we can formulate in our letters in order to command performance, okay, especially. All right, so it's down to each and every one of us. And so it's kind of like, user beware, the liability rests on you at the end of the day, and you shouldn't copy and paste anyone else, okay? But otherwise do only what you can understand, especially at this more advanced level when dealing with securities, okay? So you don't get stung with securities fraud as happened with PJP, all right? So that's all down to doing your own research, looking up your own acts, okay? And seeing what can and can't be done and trying to navigate your ship around that and indemnify yourself and, test the waters out, as it were, okay, which is what I'm doing at the moment here in Australia, which is, I'm having a bit of fun, and we'll see what happens. So that wraps up checks. So we're going to go into payment and payment systems now. So payment is the tender and acceptance of some act which discharges a monetary obligation. A monetary obligation will usually arise from the contract, and the contract may specify the act which discharges the obligation. Tender is an offer by the debtor to perform some act which will discharge the payment obligation. Okay, the act may be one specified by the contract, a conforming tender, but need not be, which is a non-conforming tender. The creditor may accept or reject the tender. Okay, the legal consequences of acceptance or rejection will depend on whether the tender is conforming, that is, whether it complies with the obligation imposed by the contract. If the creditor accepts the tender of a cheque or negotiable instrument, then payment is complete and the debt is discharged at the time when the cheque is delivered. In that particular case, so the debt will revive if the cheque is dishonoured on presentation. Legal tender denotes notes and coins which are sufficient tender to discharge an obligation to pay in money. Australian legal tender is defined by the Reserve Bank Act and the Currency Act. Okay, there is no obligation on the creditor to give change. Payment is not complete until the creditor has received the right to use the funds unconditionally. So payment by a third party to a creditor under legal compulsion on account of the debt owed by a debtor will automatically discharge the debtor's debt. That is the case even if the legal compulsion arises out of contractual obligation voluntarily assumed by the third party. In the payment system, the bank is under a contractual obligation only to its customer, not the creditor/payee. Consequently, the only way that the payment by the bank may discharge the debt is for the bank to be an agent of the customer. Okay, Good et al. In 2016 describes 4 of the most common methods of payment. This being a paper that he's published, which is 1, transfer of coins or notes, 2, transfer to creditor's account, 3, offset of items on a running account, and 4, set off. Okay, payment by set off is outside the scope of this book. Okay, but we touched on this under the accounts, and obviously the remedy that comes in behind negotiating the bills and using our bonds to bring in the passbook or the ledger that's held on the private side to set things off from the public side. All right, in this double entry bookkeeping system where we have public and private. So the transfer of value to the creditor's account is the most common non-cash method of payment. In Australia, this means payment by cheque, either cheque, direct credits or debits, BPay, FPOS, or the Pay Anyone facility offered through internet banking. Okay, regular payments such as utility bills, insurance payments, and salaries are often paid by direct credit or direct debit arrangements called standing orders in times gone. FPOS transactions have been made even more convenient and efficient by the issue of cards with embedded RFID chips. Okay, as a new payment platform becomes operational, the possibility of a true cashless society comes a step closer. So most payments are based on account transfers. An amount from the payer's bank account is transferred to the payee's bank account. Transfer is used in an informal sense, and there's no legal transfer of liabilities. It simply means that the payer's account is debited and the payee's account credited. Okay, it is convenient to all the payer's financial institution, the paying financial institution, PFI for short, and the payee's financial institution, the receiving financial institution, which is RFI for short. Okay, recall that an account is a debt owed by the bank to the customer. Okay, Foley versus Hill in that particular case. Therefore, any payment or payment system which involves the transfer of funds in an account must have its legal underpinnings based on some method of transferring debts. Common terminology refers to this as a funds transfer. It is important to realize that there are no funds transferred. It's merely an adjustment of the ledgers kept by the banks. Okay, a number of cases have acknowledged this principle. For example, in this particular case, Staunton J. said, an account transfer means the process by which some other person or institution comes to owe money to the payee or their nominee, and the obligation of the payer is extinguished or reduced pro tanto. Transfer may be a somewhat misleading word, since the original obligation is not assigned, notwithstanding dicta in one American case which speak of assignment. A new obligation by a new debtor is created. Okay, that's that principle we covered back in the first part of this mini-series. Very important, bank-customer relationship, and what are we actually dealing with? It's debts, credits owed to you on an account the bank is keeping, okay, on their ledger, which through the eyes of a banker is a debt it owes to the public or to the account holders in this special debtor-creditor relationship. So a payment instruction is called a credit order when delivered directly to the paying financial institution. It is a debit order when delivered directly to the receiving financial institution. It is often said that a credit order pushes the funds and a debit instruction pulls the funds. The concept of a payment system is any commercial and legal structure that facilitates payments by a large number of payers, okay, to a large number of payees. The obvious ambiguity of this definition is probably unavoidable. Some systems allow any bank account holder to make a payment to any other account holder. Okay, other systems restrict payees to merchants. Section 7 of the payment systems, okay, contains a definition. A payment system is a funds transfer system that facilitates the circulation of money and includes any instruments and procedures that relate to the system. Since the funds transfer is not defined in the Act, the definition is of little direct use. Similarly, the notion that the system facilitates the circulation of money is of little help since no money is transferred. However, implicit in the notion of funds transfer is a transmitter and receiver of funds. In most modern payment systems, these are financial institutions which hold accounts of payers and payees. A funds transfer in such a system is a process that results in a credit to the payee's account and a debit to the payor's account. In economic terms, a fund transfer system facilitates the circulation of institutional liabilities. Okay, an account in credit is a liability of the financial institution owed to its customer. Again, that famous case, Foley versus Hill. A payment method which results in a credit to the creditor's account and a debit to the debtors involves the transfer of liabilities. More precisely, it involves a reduction in the liability of the payer's institution to the payer and an increase in the liability of the payee's institution to the payee. Okay, as the funds leave the payer's account, there is less debt on the books of the banker for that given customer because it's now been re-established and inputted on the books at the payee's institution that now that bank has more of an obligation, more of a debt owed to that customer. So funds transfer systems from the basis of all payment systems except cryptocurrencies. We've got Section 44 of the Reserve Bank Act here in Australia now prohibits the issue of a bill or note for the payment of money payable to bearer on demand and intended for circulation. Okay, whether by a person or a state. Now this is going to be very important. Okay, Section 23 of the Currency Act forbids the issue of a piece of gold, silver, copper, nickel, bronze, or any other material, whether metal or otherwise as a token for money. So there will be a day when the cheque system is closed down, and there are good reasons to do so. The cheque system is expensive in comparison with other methods of payment, and the routing of a cheque when making a payment allows more opportunity for fraud. Clearing must be distinguished from settlement. Okay, well, clearing is essentially a sorting and accounting process. Settlement refers both to the method of payment of the resulting sums and to the payment itself. In Australia, settlement has been effected historically by cheques drawn on special accounts kept by each bank with the Reserve Bank of Australia. Okay, settlement is now done by electronic transfers between the accounts, but the Reserve Bank is still a central player in the process. Settlement in the funds transfer system is thus done by a funds transfer. The process described above is called deferred net settlement. Okay, payment orders are batched, and after the accounting is done, each bank either pays or receives the determined net amount. Note that it is theoretically possible to clear and settle payment orders one at a time rather than collect them and clear them periodically. Okay, when this is done, it is called real-time gross settlement. Okay, the Reserve Bank runs such a system for large payments. In the past, the real-time gross settlement was restricted to large payments due to practical restrictions. Okay, computer and network technology has now progressed to the point where even small payments may be cleared and settled almost instantaneously. Okay, the new payment platform does just that. It became operational in February 2018. Each payment in the new payments platform is settled individually. There is no batching and no deferment. Settlement may be by deferred net settlement, which is netting, or by real-time gross settlement. Okay, in the deferred net settlement system, payment instructions are exchanged during the day and settled the following morning by calculating the next amounts due from or to each of the parties. Settlement is achieved by adjusting accounts held with the Reserve Bank. The clearing rules provide that a payment is not final until such time as settlement occurs. Okay, we have international payments. The international banking community has established a sophisticated messaging system known as SWIFT. Everyone should be familiar with that, which stands for the Society for Worldwide Interbank Financial Transactions. Okay, SWIFT, established in 1973, is a non-profit cooperative society organized under Belgian law with headquarters in Brussels. It is wholly owned by its member banks. Okay, SWIFT is purely a computer message service and does not itself afford settlement arrangements. So the receiving financial institution acts as the agent of the payee for the purpose of receiving payment. This analysis of the payee, the payer's financial institution as agent of the payer, and the receiving financial institution as the agent of the payee is fundamental. It conclusively rejects early suggestions that a funds transfer might be an assignment, okay, or that a funds transfer instruction might be analogous to a negotiable instrument. Okay, a view rejected by the UK Court of Appeal in that particular case. So the concept of paid will usually mean either a credit to an account held by the RFI with the PFI, which is referred to as the Vostro account of the receiving financial institution at the payer's financial institution or with another financial institution. You have two, a debit to an account held by the PFI with the RFI is referred to as a Nostro account held by the payer's financial institution with the receiving financial institution's bank. So the meaning of Nostro and Vostro depends upon the point of view. Okay, if PFI maintains an account with an RFI, then the account will be a Nostro account from the PFI's point of view and a Vostro account from the RFI's, vice versa. As mentioned above, a funds transfer is a shorthand way of describing the change in institutional liabilities. As such, it is convenient when it is taken literally Okay, it is convenient. However, when it is taken literally, it can cause confusion even among experienced bankers and lawyers. Okay, and this commentary from this case where Lord Millet said, we speak of money at the bank as money passing. We speak of money at the bank and there's money passing into and out of a bank account. But of course, the account holder has no money at the bank. Money paid into a bank account belongs legally and beneficially to the bank and not to the account holder. The bank gives value. Now that's the only time that changes, okay, is when there's a trust account. All right, and that's obviously where the constructive trust comes in. It's a slightly different relationship then. So notice here, legally, okay, the money paid into a bank account belongs legally and beneficially to the bank and not to the account holder. So the bank gives value for it, and it is accordingly not usually possible to make the money itself the subject of an adverse claim. Instead, a claimant normally sues the account holder rather than the bank and lays claim to the proceeds of the money in his hands. These consist of the debt or part of the debt due to him from the bank. We speak of tracing money into and out of the account, but there is no money in the account. There is merely a single debt of an amount equal to the final balance standing to the credit of the account holder. No money passes from paying bank to receiving bank or through the clearing system, where the money flows may be in the opposite direction. There is simply a series of debits and credits which are causally and transactionally linked. Lord Millet's reference to the clearing system, okay, where the money flows maybe in the opposite direction, is reference to settlement. Okay, so again, a very, very important concept to take away, that you got another great quote as part of a case, okay, that reinforces that fact. So domestic payments are more production line products, whereas international payments are more tailor-made. Okay, the automatic handling of payments is governed by interbank agreements known as clearing rules and by the rules established by the Australian Payments and Clearing Association. We've got direct debit operations pose more of a threat. The individual payers giving another party authorization to operate on the payer's account. Originally, these authorizations were required to be given to the payer's bank. A streamlined method was implemented in March 2000, which required the payer to authorize the payee organization, okay, directly. There is nothing wrong with the new procedure, but difficulties arose when the payer wished to cancel the direct debit arrangement. Some banks refused to act on their customers' wishes, claiming that the customer needed to approach the organization directly. This was, of course, wrong in law. The Banking and Financial Services Ombudsman, okay, now the AFCA, indicated that would take a dim view of this attitude. Okay, the problem should now be settled since the Banking Code of Practice requires banks to act on their customers' instructions. So debit card and PIN serve as authentication and authorization, much as a signature operates on a check. CHAPS stands for London Clearinghouse Automated Payment System. It's another huge clearinghouse. Informal funds transfer system. An informal funds transfer system is a system used to transfer funds internationally that operates outside the normal banking systems. You guys might want to take note of this. It's quite interesting. There is no standard terminology. The Financial Action Task Force refers to them as alternative funds transfer systems, okay, but notes that they are also referred to by regional names such as Hawala, Hundi, and Paydala. So the IFTs are often treated in the press as something mysterious. Okay, a 2001 article in the New York Times refers to ancient secret systems which transfer funds but in which no cash moves across a border. Even official publications seem to assume that there is something unusual in the way that IFTs operate. The Interpol website contains an article, The Hawala Alternative Remittance Systems and its Role in Money Laundering, which describes in detail methods used to transfer funds, but which does not observe that the methods are precisely those used in the ordinary financial system. So Express and Diners Club are the two major travel and entertainment cards in use in Australia. Credit cards are not an efficient payment mechanism due to the very high transaction costs. However, active promotions, okay, by regulators and other businesses in the form of reward schemes has led to a substantial increase in credit card use. For example, here in Australia in 1990, there were over 18 million credit card transactions each month. In 2007, that figure had risen to 180 million per month, then to more than 162 million per month in 2013. So you imagine what it is now, it's probably even more. So they're usually the credit economy, right? That's what's filling the gap between suppressed real wages, okay, and the prices of everything going up because of this practice of, again, what? money creation, banks as credit creators. Okay, and so what's filling the void in order to actually get people to purchase things is finance, credit, the credit economy. So there are usually four parties involved in a credit card payment. A financial institution, the issuer, will provide a credit card to its customer, the cardholder. Okay, a person authorized to receive payment by credit card is known as the merchant. The merchant's financial institution is known as the merchant acquirer. So Australian credit card transactions from August 2014 are not signature-based, but require the use of a PIN. We have computer money. There are three main forms. You've got the digital cash, the smart cards, and cryptographic currency, referred to as cryptocurrency. We have the new payment platform. Began life in 2012 when the Reserve Bank published the results of a study into innovation in the payment system. Okay, the report set out objectives for a new payment system to replace the existing customer payment system. The objectives included users should be able to make real-time payments, messages should contain more information about the purpose of the payment, payment orders should be easily addressable in a form that minimizes mistakes, and the system should operate around the clock. So the Reserve Bank later expanded on these objectives in cooperation with an industry committee and the Australian Prudential Regulation Authority. The new infrastructure was formally proposed in February 2013. Okay, funding was committed by a group of 12 ADIs who became the founding members of the new payment platform Australia Limited. So these guys contracted with Swift to design and implement the infrastructure. BPay agreed in 2015 to become a user of the new payments platform once the system became operational. The system became available to the public in February 2018. The APRA website contains more information concerning the development and progress of the new payments platform. Okay, so the NPP provides near real-time clearing and settlement. Current indications that this has resulted in clearing and settlement times in the order of 6 seconds for individual payments. Okay, it's quick. The resulting elimination of all net deferred settlement for electronic payments has substantially reduced the exposure risk for the Australian payment system. Australia's fast payment system is one of the few in the world that provides a real-time transaction-by-transaction settlement of retail payments 24 hours a day, 7 days a week. Take-up of the NPP has been slow but steady, comparing favourably with our fast payment services in other countries. You can see a speech there by Michelle Bullock, who was the current Secretary or Chair of the Reserve Bank of Australia at the time. I don't know if she still is. So blockchains and cryptocurrencies, Bitcoin is unsuitable for large-scale payment systems. Okay, the most likely to succeed is Facebook's DM, even though I don't think that's going to be the case. The appeal of blockchains is that they form the basis of public autonomous database. Okay, public means that anyone may participate in the operation of the blockchain. Autonomous means that nobody's in charge of the operation. Okay, decentralized, the starfish and the spider. So the total processing capability of Bitcoin is hopelessly low. The best estimates are that Bitcoin can process about 7 transactions per second. Okay, Visa and MasterCard processes thousands per second. Some estimates are as high as 26,000 per second. So it's obviously a lot inferior in that sense. Stablecoins form a subclass of altcoins. The defining feature is that a stablecoin is backed by a real asset, okay, or its value is tied to an existing fiat currency or bundle of currencies. The most visible of these stablecoins is Facebook's DM. The rise, however, the rise of neobanks has solved the problem DM set out to address in regards to the unbanked. Okay, so a digital identity system coupled with the DM payment system, coupled with Facebook's social media platform, has staggering privacy implications. As long ago as 1974, Douglas J. in California Bankers Association versus Schultz, okay, said at 85, in a sense, a person is defined by the checks he writes. By examining them, the agents get to know his doctors, lawyers, creditors, political allies, social connections, religious affiliations, education interests, the papers and magazines he reads, and so on ad infinitum. Okay, when applied to a modern electronic payment system, the concerns increase by orders of magnitude, and that's certainly the world we're living in today, isn't it? With the surveillance, the mass surveillance state, which is why, a very powerful document to get done as a claimant in order to withdraw your consent is to safeguard your privacy, okay, and stop the sharing of all your data, and to make sure you're cognizant of all these devices, right, that you can go into the settings that, again, through these corporations and their bylaws and terms and conditions, most people don't read, and, by default, agree for them to record and harvest your data and send it off to these individuals. So it's very important for us to, be wise owls during these times and pay attention to the small print and take action when withdrawing our consent or going onto these devices into settings and withdrawing it that way by simply, pressing no, for data gathering, etc. This applies to everything and anything, right? Phones, laptops, computers, even with our banks and even with the governments, when obviously sending the withdrawal of consent under Data Protection Act or the Privacy Act, whatever it's called in your given bankrupt corporate state, okay? Right, folks, so that wraps up checks and payment systems. So I'll see you over into the next one, the last one, where we're going to be going over lending and secured lending, bankers lien, which is just going to touch back on this principle of securities and securitization, otherwise covered in kind of Article 9, but looking at a more of a banker's lens. Okay, I'm going to cover a little bit more on accommodation bills and accommodation party too, okay, which shed more light on bills of exchange, which is what we did in the previous video. All right, folks, I'll see you then. Take care.